Super, and hopefully everyone can see my slides. Apologies that it's not in screen slideshow mode, but hopefully everyone can see them. I'm going to take silence as a yes. Super. Right, Stephen, thank you very much.
So good morning, everyone. Welcome to the UKUPC training session on Spotlight on the Selection Stage. We're joined today by Christopher Murray and Helen Rowland from Evershed Sutherland, and they will be taking you through the presentation. And I'll pass you over to them now.
Super, thank you very much, and great to be with you all. So today we are going to be discussing the new rules for assessing suppliers' financial standing and technical ability. We'll look at the concepts of excluded and excludable suppliers, which are new under the regulations, under the Act. I must get used to saying Act. We will then look at the new centralised debarment system, and we'll do a bit of Q&A at the end. Given the content that we need to get through and the amount of people that are on the call, it would probably be best if we deal with questions at the end. So if you just put them in the chat, as Stephen said, we will pick them up at the end and make sure we leave ourselves enough time to do that. So just in terms of background to the Act, obviously the United Kingdom voted to leave the European Union back in 2016, June 2016, a mere 8 years ago, and in October of this year, the Procurement Act will come into force. So the bill was announced in the Queen's speech in May 2022. That was the second time around, because it had been announced in the previous Queen's speech as well, but didn't get off the ground in that Parliament. It received royal assent.
Chris, sorry, you've gone on mute, I think.
I have. I am not sure why I've gone on mute. Perhaps somebody was bored of listening to me already. But let me know if that happened again, Helen, and I will come off. Sorry, I was saying after a mammoth journey through Parliament, the Act will come into force on the 28th of October of this year. The commencement regulations have been made, so there was a bit of uncertainty before the general election was called. That was the date that the government was targeting, but the Minister for the Cabinet Office signed those commencement regulations just before Parliament was dissolved, so the Act will come into force on the 28th of October. Currently, there are consultations. Consultations are complete, and the government is in the process of preparing certain draft regulations under the Act. A first set of regulations, the Procurement Regulations 2024, have been made. They deal with things largely related to the new transparency agenda, notices, etc. And we're expecting a second set of regulations to deal with things like calculations for the old TECAL type arrangements, and other various pieces of secondary legislation. There's lots of resources that are available: guidance note, knowledge drops, deep dives, e-learning modules, and contracting authorities are encouraged to take the government up on the offer. So Helen and I like to talk a lot about the procurement life cycle, and I think it's important, just for context of this session, to put what we are talking about today in the context of that procurement life cycle, because the Act does introduce a fair amount of kind of quite significant change at all stages of the procurement life cycle, and selection is just one of them. We will focus on selection, but there are other areas. So if you look, for example, at pre-market engagement, there's much greater encouragement and much greater scope as to what would be permitted in a pre-market engagement. If you look at some of these notices that are being referred to, there's far more notices under the Act. the selection stage is obviously the point that we will focus on today. Tender stage, important changes around choice of procedures. So obviously we've got rid of a lot of the old, what the government called dated procedures, competitive dialogue, competitive procedure with negotiation, and those have been replaced with just two procedures. One is the open and the other is the competitive flexible procedure. So there's quite important changes there as to what will happen. Flowing through then the procurement life cycle, you get the tender assessment, and then another important area of change is around assessment summaries and contract award notices. So the assessment summary is the replacement to a what you might call a standstill letter or a Regulation 86 notice. And then we have a contract award notice, which is not the old contract award notice, just to confuse things, but it's a notice that is published before the standstill period kicks in. We have a new 8 working day standstill period as opposed to the old 10 calendar day standstill period. And then again, just flowing through that life cycle, you get to award, contract details, and then into modifications, contract modifications, KPI monitoring, and things like that. And Helen's going to pick up on that later on. But just important to note that there are changes throughout the procurement life cycle, and what we are focusing on today is just one element of that. So we are familiar, I guess, with using terms like selection stage, selection criteria. That terminology will change, and we're now talking about conditions of participation. So conditions of participation are essentially what we now call selection criteria. It is a concept that we're obviously familiar with. Selection criteria are essentially backward-facing criteria, looking at experience and financial capacity, as opposed to forward-looking criteria in terms of how a particular bidder would deliver a contract. The new conditions of participation are set out in section 22 of the Act, and it says that they must be a proportionate means of ensuring that suppliers have legal and financial capacity and technical ability in order to deliver the contract. So the legal part of that is presumably a reference to the excluded, excludable, exclusion ground type points that we'll talk about in a minute. We then have financial capacity and technical ability, which are all relatively familiar concepts just now, because they are the sort of things that we test at a selection stage of a procurement process currently. So for example, if you're used to using the government standard form SQ selection questionnaire, that is essentially what that does. It tests experience and financial capacity as well as compliance with exclusion grounds. So this isn't kind of a new concept, it is new terminology for what we currently have, but there's certainly some clarity in respect of this stage. There's a question mark over whether or not the conditions of participation have to be related to the subject matter of the contract, because there's no specific requirement in the Act that states that they do, unlike award criteria. So section 23 of the Act very clearly says that award criteria have to be related to the subject matter of the contract. So that's a bit of a kind of question mark as to whether contracting authorities can take into account slightly wider conditions as part of this stage of the procurement process. And then there's also rules now, or at least there is an express allowance for contracting authorities to potentially require evidence that is verifiable by third parties. Again, that is, I think, quite an interesting development. There is no such express allowance in the current regulations for evidence to be verifiable by third parties, but it is obviously fairly commonplace for contracting authorities to require or request evidence that may be verifiable as part of an SQ process just now. So if you look, for example, at things like credit checks, now credit checks are quite a common means of assessing a supplier's financial capacity, but essentially that is evidence that's verifiable by a third party. We would say often to our contracting authority clients that if you're using credit checks, you need to be careful around their use, because essentially what you are doing is handing over an element of that assessment to a third party. Another or other evidence that might be viable by a third party at this particular stage of the procurement process is, for example, a reference. So a reference from a referee. And now those are tricky from a procurement perspective, because obviously references can be fairly subjective. It's someone's view as to how a supplier delivered a previous contract, and it may be the case that the supplier disagrees with the referee's reference. So whilst there is this new express provision to allow evidence that's verifiable by third parties, it's worth, I think, approaching that with a degree of caution. Just continue on with some more general points then. The Act allows a contracting authority under section 22 subsection 7 to it gives contracting authorities the discretion to exclude from further participation in a procurement process a bidder that does not satisfy a condition of participation. So it is up to the contracting authority at this stage in the process to progress a bidder or not in circumstances where that bidder has not met one of the conditions of participation. However, under section 19 of the Act, a contracting authority must disregard a tender from any supplier that does not meet a condition of participation. So this is of relevance in the context of the competitive flexible procedure that I mentioned earlier on, one of the kind of more complex procurement processes. You will obviously run a kind of participation process, a selection stage at the start of that procedure in order to identify the bidders that you'll take forward into the CFP stage. And it may be the case, certainly you're allowed under the Act, to progress someone that hasn't actually met one of your conditions of participation. I guess the expectation there is that that supplier might be able, throughout the course of that procurement process, to satisfy the condition of participation. But if they don't, they cannot be awarded the contract at the end of it. So if they're identified as the most economic, or so the most advantageous tender at the end of the process, they wouldn't be able to be awarded the contract. So you as contracting authorities would be, I think, accepting a degree of risk if you progressed a bidder at the participation stage or the selection stage that didn't meet a condition of participation, because it is possible that by the end of the process they still wouldn't have met that. So I think that's another area to be particularly aware of. It's now also clear, although as it is just now, that suppliers can rely on others in order to satisfy certain conditions of participation, or the conditions of participation. So that's an organisation that they are bidding together with, or an organisation where the authority is satisfied that the supplier will enter into a legally binding subcontract or a guarantee arrangement. So suppliers are allowed to rely on others in order to meet experience thresholds or financial standing thresholds. The participation period, just in terms of timescales, the participation period is set out in section 54 of the Act, and it is generally 25 days. So again, this is in the context of CFP. In an open procedure, you won't have a distinct participation stage, but in a CFP, a competitive flexible procedure, you would, and generally that period needs to be at least 25 days. that can be reduced down to 10 days in cases of urgency, and in the context of light touch procurements, there is no minimum period. And then it's also worth noting, just in terms of the new central digital platform, the idea is that bidders will input all of this information once, and then they're able to use that in other procurement processes or numerous procurement processes, so they're not constantly having to input the same information every single time. So it should cut down on the kind of bureaucracy and red tape. It's important though for suppliers and indeed for contracting authorities to recognise that if that information is updated, it needs to then be updated in the central digital platform. Otherwise, the contracting authority may well be working off of dated information. Just in terms of the two kind of key areas of a selection stage or a participation stage, looking at technical ability, the Act talks about that covering qualifications, experience, technical ability. One of the changes under the Act, there's no limit on the age of the experience. So right now there are rules that say, under Regulation 60, there are rules that say that experience examples for a works contract should generally be from within the past 5 years, and experience examples for services and supplies should be from within the past 3 years. There is no such limits under the Act. And then in terms of how you would evaluate those, it's things like using case studies, CVs, qualitative questions. None of this is set out in the Act itself, but this is the kind of common approach to assessing technical ability just now, and that shouldn't change. In terms of financial capacity, this is about ensuring that suppliers are in a strong financial position to perform the contract if they were to be awarded it. It's to protect against Carillion type examples where you have an organisation that's being awarded lots of public contracts but clearly is in financial distress. So robust financial capacity evaluations are required. That involves assessing things like turnover, assets, liabilities, different ratios, pending litigation. And usually that's done by way of reviewing financial statements. Now, under the Act, there's a couple of changes in respect of financial capacity. The contracting authority cannot generally require the submission of audited accounts. There is some exceptions to that, but they should not be asking suppliers to submit their audited accounts. Now, that's actually the position just now. Contracting authorities should not be requiring bidders to provide information which is freely available in the public, which financial accounts generally are on Companies House or on the company's website. And in fact, the SQ right now doesn't actually, the standard question, the SQ doesn't actually require bidders to submit their audited accounts. It says, if asked, would you be able to do that? But a lot of contracting authorities change that question and simply ask for the financial statements to be submitted. So it'd be interesting to see whether this change, which is certainly a change in terms of the express provisions of the law, whether it actually changes practice in the future or not. Another change is that contracting authorities cannot require insurances to be in place before the contract is awarded. So if a certain level of insurance is required because of particular risks associated with your individual contract or your individual project, you cannot require a bidder to have that for the purposes of participating in the procurement process. It only has to be in place at the point at which they are awarded the contract. So just moving on to excluded, excludable. These are new terms, but they're not really new concepts under the regulations. Under the Act. I've done it again. This is an area of the Act that I particularly like, and the reason for it is that the rules are set out in section 57 of the Act. And for those procurement law geeks, you will know that right now the mandatory and discretionary exclusion grounds are set out in regulation 57 of the regulations. So there's a commonality of numbering there, which I appreciate. Excluded, an excluded bidder is essentially a bidder where one of the mandatory exclusion grounds applies, or the supplier is on the debarment list for a mandatory ground, and Helen's going to talk about debarment in a bit. An excludable supplier then is a supplier where the discretionary exclusion ground applies, or the supplier is on the debarment list for a discretionary ground. So for excluded, they are essentially excluded, as the name suggests. They cannot proceed in the procurement process. For excludable, there's a discretion there for the contracting authority to decide whether or not they want to allow that supplier to continue on in the procurement process. Now, as I say, these are new concepts, excluded, excludable, sorry, new terms, excluded, excludable, but they're not new concepts because we're very familiar with the mandatory and discretionary exclusion grounds, and in particular with contracting authorities exercising that discretion, or indeed not exercising the discretion to exclude in the context of a discretionary exclusion grounds. There are some new and extended grounds. I don't intend to go into them in any detail here, except poor performance, which is one that Helen is going to pick up in a minute. But there are some kind of important changes to those exclusion grounds that contracting authorities will have to be familiar with. The exclusion grounds are set out in Schedules 6 for mandatory and 7 for discretionary of the Act. Just continuing on then, the concepts of excluded and excludable, we still have self-cleaning in respect of that. So the Section 58 of the Act says that the circumstances giving rise to the application of an exclusion ground are continuing or likely to occur again. So if they're not continuing or they're not likely to occur again, then the supplier is essentially deemed to have self-cleaned, and they shouldn't be excluded from the procurement process. And in terms of that process of self-cleaning, or what would be sufficient for self-cleaning, the Act talks about the supplier providing evidence that they've taken the circumstances seriously. For example, they may have paid compensation. They've put in place prevention methods to stop the issue from reoccurring, and that might include, for example, changing staff or management structures, or putting in place procedures or training programs. It is also sufficient in certain circumstances for commitments on any of that to be made. So it may not be that the supplier has in fact actually been able to roll out the training required, but they have a commitment in place to do that, and that may be sufficient for a contracting authority to essentially decide that the bidder had self-cleaned. And another point in terms of self-cleaning is the time that has elapsed between the offence or the incident or the event and the point at which they are participating in the procurement process, on the assumption that more dated offences are potentially there's greater ability for a supplier to have self-cleaned if the offence was dated, and then there's just wider kind of other circumstances that the contracting authority can take into account. So it's important to know that self-cleaning is still something that suppliers can do, and contracting authorities have to ensure that they are acting proportionately when they look at the evidence of self-cleaning. A couple of other tweaks then. Offences outside of the UK will be caught if those are offences, if they would have been an offence if they were committed in the UK. Suppliers can be excluded if subcontractors are subject to any mandatory or discretionary exclusion grounds, but there is an opportunity for the supplier to replace the subcontractor or the associated supplier, which is the term that's used in the Act. The look-back period for discretionary grounds will generally move to 5 years, which is the same as the mandatory period, and that is different to what we have just now. Discretionary grounds, the look-back period is 3 years, and for mandatory grounds, the look-back period is 5 years. And then there's some specific changes, probably not too relevant in the context of this discussion today, where private utilities are essentially all of the grounds are treated as discretionary. So even the mandatory grounds for certain offences will be treated as discretionary grounds, but that is similar to the position that's under the utilities contracts regulations at present. So I've probably cantered through that faster than I should have, because I thought we were going to run out of time, but I'll hand over now to Helen, and Helen, you just let me know when you want me to move slides on, okay?
Great, thanks. Sorry, Chris, my technical difficulties are continuing because I couldn't come off mute, but hopefully now you can all hear me.
You can indeed.
Great. So as Chris has just mentioned, the grounds which gave rise to a supplier being either excluded or excludable have been extended under the Act. And that includes in relation to the current discretionary ground for breach of contract. So under the current regime, we have a discretionary exclusion ground. So a supplier would be considered excludable where there's been a breach of contract, which has resulted in early termination, damages, or some form of comparable sanctions. And that's generally considered to be quite a high hurdle because before poor performance could be used to justify a supplier's exclusion, it requires there to be something sufficiently serious. So there has to be this breach of contract, and that breach, as I say, is sufficiently serious to require either early termination and or the award of damages. And given the high profile examples of failures of public contracts, and Chris referred earlier to Carillion and similar cases, so it's long been a concern to make sure that there are sort of adequate provisions to deal with and suitable sanctions for suppliers who are providing a sort of inadequate or unsuitable service under a public contract, because obviously there's public money involved. So whilst that provision has been retained under the Act, and so will apply in similar terms, so if there's a breach of contract, it has also been extended to include where the supplier has not performed to the authority's satisfaction. The supplier has been given an opportunity to improve its performance, but it's failed to do so. And there are actually two provisions in the Act which effectively do that. So one provides just that, as I've said, sets it out in those terms. So where a supplier will be excludable if they have not performed the contract to the authority's satisfaction, they've been given an opportunity to improve their performance and they failed to do so. And the other provision, which effectively does the same, refers to a supplier being excludable where an authority has published information under Section 71(5) of the Act. Now, Section 71(5) of the Act requires a contract performance notice to be published where there's been poor performance, they've been given an opportunity to remedy or improve the position, and they failed to do so. So it's all very circular, we come out in the same place. So given sorry, Chris, the slides have gone, I think, on my screen anyway. So given authorities required to publish a contract performance notice where there's been poor performance which has not been improved or remedied, they both, in effect, have the same outcome. So either way, this lowers the previously high hurdle. So in terms of the supplier not performing the contract to the authority's satisfaction, this doesn't actually require there to be a breach of contract anymore. So obviously, if there is a breach of contract, that is still a discretionary exclusion ground. And it can be used as evidence of failure to perform, but there doesn't have to be that breach. There can just be a failure to perform, whatever that means, because obviously it's very subjective, it's potentially extremely wide, and it is likely to be fiercely resisted by suppliers. And we see that a lot with the changes I'm going to talk about today with the debarment. Is there are a lot of things here where suppliers are likely to push back on. They're not going to be happy, not least because it can cause reputational damage in terms of having notices published which refer to poor performance, but also because of the severe consequences, as we'll come on to look at, of maybe ending up on the debarment list. So under the Act, for contracts where the value is estimated to be over £5 million, authorities have to set and publish at least 3 KPIs, and a supplier's performance then has to be assessed. And again, the results of that assessment published against those KPIs at least once every 12 months. And if a supplier isn't meeting those KPIs, then a contract performance notice will be published. And that's the notice under section 71.5 that I've just been talking about. But contract performance notices, so 71.5, not just restricted to contracts where the value is over £5 million. For contracts below that value, contract performance notices will still need to be published where there is poor performance by a supplier. They've been given the opportunity to improve or remedy that performance and they failed to do so. But because there aren't those published KPIs for those contracts, authorities will need to be careful and sort of carefully consider what evidence there is and how robust that evidence is to demonstrate that poor performance. So there's no requirement, as I've said, under the Act for contracts and with a value of under £5 million to set and publish KPIs. Obviously, KPIs are good practice with all contracts and can then be used as a useful metric for measuring suppliers' performance, provided they're clearly set out, they're agreed with the supplier, and they're monitored throughout the duration of the contract. So interestingly, there is provision within the Act which provides for a general exemption from publication if the authority is satisfied that the information contained within, say, a contract performance notice is considered commercially sensitive, and so there's an overriding public interest in it being withheld from publication. But given the idea with these notices that are there's a number of them throughout the Act, is to increase transparency, and that is very much driven by the public interest. This exemption seems to have fairly limited utility, as I think the only real reason a supplier would basically have to say it's in the public interest to withhold this information because it would harm our commercial interests, which sort of then brings it back, well, actually, it's in the public interest for the public to know if there are issues with the performance of public contracts. So it'd be interesting to see if there are any cases when the Act comes into force where publication is withheld on that basis. So all of this shows the importance of ensuring KPIs are met, that they are realistic and attainable when set, and that they're kept under review throughout the duration of the contract, and there are regular contract review meetings, they're conducted, proper records are kept of those as well, and it's just to emphasize the importance and where this could go. Can I have the next slide, please, Chris? Okay, so the debarment list is an entirely new feature of the Act, and it's fair to say it's generated quite a lot of interest. It's something that probably is precluded if we were still in the EU, but as Chris said, we are no longer and have not been for something, what was it, decision 8 years ago, which feels just like yesterday. Anyway, by adding a supplier to the debarment list, the authority will be able to exclude a supplier from all future procurements automatically for a specified period of time, or it will require authorities to exercise their discretion as to whether to exclude a supplier in future procurements. And the aim of the list is to take tougher action on underperforming or unsuitable suppliers. It aims to reduce the risk to contract delivery and public funds, and also maintain public confidence in suppliers and the delivery of public contracts. Whereas exclusion grounds and whether a supplier is excluded or excludable is an authority decision, the debarment list is a centrally managed list by the government, but it doesn't replace an authority's consideration of whether the exclusion grounds apply. And as Chris said, this is still something that will need to be considered at selection stage. So we're just going to run through how a supplier might find its way onto the list. So having ascertained that there are grounds which give rise to a supplier either being excluded or excludable, so whether there's discretionary or mandatory exclusion grounds, if a supplier is not on the debarment list already, the authority must consider whether the circumstances giving rise to the ground of exclusion are continuing or likely to occur again. So as Chris mentioned earlier, we still have the self-cleaning concept under the Act, but there is greater flexibility under the Act over what self-cleaning evidence can be considered, and suppliers have the right to representations about their potential exclusion. So now in making their decision, authorities should be looking at any evidence that the supplier or an associated supplier or connected person has taken the circumstances seriously, any steps they've taken to prevent it happening again, or a commitment to take such steps, and as Chris ran us through some of them earlier, but things like changing staff or management, revising policies, procedures, updating training materials, holding more regular training and so forth, the time that's lapsed since the circumstances last occurred, and obviously any other appropriate evidence. And authorities won't actually be able to request specific pieces of evidence unless it's proportionate to the circumstances. So as Chris said, you need to be thinking, is it proportionate to do this? We can't ask them to provide us with absolutely everything. We need to be pinpointing something. So the onus really is on suppliers to provide the evidence which they consider demonstrates their ability to self-clean or that they have already self-cleaned. Now, if the authority is not satisfied, having reviewed that evidence, fully considered, maybe asked for further information if it's proportionate to do so, that sufficient steps have or would be taken to prevent the issue reoccurring, then the authority must notify the Cabinet Office within 30 days of the exclusion. And once the Cabinet Office, or it's actually going to be the debarment review system, I think, is notified of an exclusion, it may decide to commence an investigation. Now, it's may not must, and it's not entirely clear at the moment when they will decide to commence an investigation and where they won't. But if an investigation does take place, so the DRS will review evidence as to whether the supplier is excluded or excludable. And if the supplier is determined to be excluded or excludable, when that will cease to be the case, so how long they should be on the list. And after the investigation has concluded, the DRS Cabinet Office will publish a report of the findings of that investigation. And if they determine that a supplier should be added to the debarment list, there will be an 8 working day standstill period, which will run from the date the notice of the decision is given. So, as Chris said, if a supplier is added to the list for a discretionary exclusion ground, there'll be an excludable supplier. So authorities will retain a discretion as to whether or not to exclude them from future procurements. If a supplier is placed on the debarment list for mandatory exclusion ground, there'll be an excluded supplier. So they'll be excluded from all future procurements whilst they remain on the list. And there's no opportunity then for them to provide evidence of self-cleaning, whereas excludable suppliers, each time they try to participate in a procurement, will have the opportunity to provide evidence of self-cleaning, and then it'll be for the authority to consider whether to exercise its discretion to exclude or not. So for practical purposes, for suppliers, inclusion as an excludable supplier may be quite similar to inclusion rather as an excluded supplier if the authority exercises its discretion to exclude. But authorities will need to make sure that that discretion is exercised properly, as is always the case when exercising discretion, as a supplier could potentially challenge an authority's decision to exclude on the basis of irrationality or bias and so forth. Suppliers are very much expected to actively engage in the process, and you'd hope they would, given the consequences if they don't, and provide any relevant information. And actually, having said that, if they don't engage in the process, that in itself actually renders them an excludable supplier, and so could be enough in itself to justify entry onto the debarment list, irrespective of whether the initial ground which gave rise to the investigation is upheld or not. And one other point is, given the report will be published, suppliers will also likely want to engage in discussions around any redactions to be applied in respect of any confidential or commercially sensitive information which is included within that report. So next slide. Great. So once the Cabinet Office, DRS, publishes its report, and that report confirms that the supplier should be added to the debarment list, whether as an excluded supplier or an excludable supplier, as I said, there's an 8 working day standstill period. And during that period, the supplier can appeal its inclusion on the list. And that appeal process, so that 8 days, provides important interim relief for suppliers, as if they lodge an appeal within that standstill period, then it triggers an automatic suspension, so similar to what we have currently if a claim is issued in the standstill period, which means that until the appeal is determined, discontinued, otherwise disposed of, the supplier will not be added to the debarment list. Now, if an appeal is not brought within the standstill period, suppliers still have 30 days from when they knew or ought to have known of the decision to challenge the decision. To challenge the decision to add them to the debarment list. So that's the same sort of 30-day limitation period that we're used to under the current Act. But that won't, if it's brought outside of the 8 working days standstill period, that won't trigger the automatic suspension. So during that period, say if they do it on the 9th day, 10th day, they will be added to the debarment list for that period. And courts will only intervene if that decision is challenged where there's been a material mistake of law, or some manifest error in the judgment or assessment by the authority in making its decision to exclude. And given that a decision that a supplier is excluded, so not excludable, that's slightly different, tends to relate to offences which the supplier either has or hasn't committed, that provides sort of a fairly limited scope, I'd have thought, for excluded suppliers to appeal, for there to be a sort of mistake of law. So applications can be made for removal from the list outside of this period, but only if there's been a material change in circumstances or there's significant new information available since the supplier was added to the list. And the remedy, if a challenge is successful, is for the supplier to be removed from the list. But in terms of any damages or compensation, because obviously suppliers, may say that that's caused them reputational harm to be on that list and it's harmed their commercial interests. Actually, the remedy is that are limited to any costs incurred in participating in the procurement where they were determined to be excluded or excludable. So that's just their tender costs for that specific procurement and nothing wider than that. Next slide, please, Chris. And so just to round up, given the potential consequences of being added to the debarment list, which could result in insolvency for some bidders if they're not able to participate in procurements for a number of years, a decision to exclude is likely to be contentious and subject to increased scrutiny. So authorities should be looking to develop comprehensive guidelines that set out procedures to be followed for determining whether exclusion grounds apply. So particularly in terms of exercising that discretion as to whether or not to exclude, the process for reporting any exclusions, both internally and externally. And the amended self-cleaning test, which we've talked about, means that suppliers are allowed to submit evidence and make representations that circumstances are not likely to reoccur, and careful consideration needs to be given to any evidence that's submitted. With excludable suppliers on the debarment list, obviously authorities have that discretion as to whether or not they should be excluded from participating in a procurement. And in exercising that discretion, authorities should have regard to public law principles, so that's make sure that you're acting rationally, fairly, and without actual or apparent bias, because failure to do so could result in a challenge from the supplier. As is always the case with decisions in procurement, detailed records should be kept of all decisions, and that's absolutely crucial to be able to demonstrate the reasons for the decisions taken, the process that's been followed, and it provides transparency in the event of a challenge. And given the consequences, as I've said, authorities can expect that suppliers will push back fairly robustly, I'd have thought, on any decision to exclude them. So authorities should make sure that their decision making is properly documented and clearly supported by evidence. And the new transparency requirements, require authorities to review suppliers' performance every 12 months if the contract is over £5 million, or the requirement to publish a notice where there is a poor performance by a supplier, or the requirement for certain public contracts to have a minimum of 3 KPIs, and that failing to meet those KPIs could see suppliers end up on the debarment list, means that poor performance by a supplier is much more likely to be in the public domain, potentially very harmful to a supplier. And that actually may make suppliers not just more likely to challenge such decisions, but actually to think about maybe being more selective as to which contracts they'll be bidding for in the future. That's me done. Time for some questions.
In our haste, because we were slow to start, we've probably skimmed through it. Indeed, because I've got the slides on the screen, I can't see the questions coming through. I guess one point that I was going to just pick up on the points that you were just discussing there, Helen, is another dimension, I think, to the debarment and the increased transparency is not only, as you say, that suppliers are more likely to kind of robustly defend or challenge those sorts of decisions, but because of the transparency, it might be a technique for suppliers to get a kind of one up on their competitors. So if their competitors are on the debarment list for a discretionary exclusion ground, but a contracting authority hasn't exercised its discretion to exclude that competitor, you might find that the supplier seeks to challenge that, if they're particularly vexed about the way in which their competitors have been operating. And I think some of this stuff around debarment, because it's all done at a kind of central level, obviously there's an important role there for individual contracting authorities, but because quite a lot of this is done at a central level, you might feel as a contracting authority that you're a little bit removed from it, but actually you might also find that you are in the crosshairs of competitors who are trying to get at one another, and the way in which they do that is perhaps through your procurement process. So I think that's kind of an interesting potential area of risk as well.
Well, quite. I'd have thought, suppliers are operating in a very competitive market as it is, and I think one of the things with this increased transparency is they will be looking what are their competitors up to, and if particularly, say a supplier is excludable in a future procurement, and they'll be monitoring the performance of that, or even if they're just unsuccessful, they'll be looking for information, and they will use that as then the basis for challenging that award of the contract. And the way to do that, they won't be able to challenge the supplier or the successful supplier, is they'll go through the authority. So I think there is certainly going to be a lot more sort of pre-action scurries, if not more. So questions.
There are some in the chat. I don't know if you can see them, so I'll just run through those and then I'll come to Karen, who has her hand up. So the first one is, how or where do we check for pending litigation, please?
Okay, so pending litigation, there is no way you can check for that. In terms of, you can only check once a claim has actually been issued, and then you can check with the courts against party names. But in terms of pending litigation, so I assume you mean things like pre-action. So if there's a letter received, say, following during the standstill period, and there's correspondence, there's no way of checking that litigate. And in terms of if this goes to sort of exclusion grounds, probably until there's actually a case or a judgment, it's unlikely to be considered relevant either. But yeah, there's no way of checking for pending litigation.
I guess just that might have arisen out of the part that I was talking about, in that the SQ or the future equivalent of the SQ may have a question that says, is there any specific pending litigation which would impact on your financial standing, for example. So it would be a question that was asked, and as Helen says, it would probably be the sort of thing that there might be pre-action correspondence on, you otherwise wouldn't know about it, but you're essentially asking the supplier to tell you transparently whether they've got any particular risks around pending litigation. perhaps. But we haven't seen the documents that will come out, the kind of standard form documents that will come out under the Act yet.
Another question, somebody's working on a project designed to boost the local economy. Is there any scope to account for locality of suppliers directly or as subcontractors within the selection stage? I.e., can they give extra points to suppliers from or using subcontractors from the city in question?
Well, yeah, the use of the word local is a kind of age-old difficulty from a procurement perspective, because obviously one of the fundamental principles of procurement law is non-discrimination, and that continues on. So contracting authorities cannot discriminate against treaty state suppliers nowadays. So if you are a Spanish supplier, you in theory have an equal opportunity to participate in an individual procurement process. So I think that the use of the word local in any procurement process, or those sorts of mechanisms, I think will continue to be difficult. Now, that's not to say that contracting authorities don't do it. Many contracting authorities do, and there are obvious advantages to using local supply chains and local products. But it's usually done in a fairly nuanced way at the minute, and I think that will just continue on, if I'm honest.
And another one, what happens if you're already contracted with a supplier who becomes excluded or debarred?
That's a good question.
Do you want me to take that, Chris?
Yeah.
I think it is a good question. I'm not sure it's necessarily played out in the Act. My view is probably that when you say you've already contracted, if the contract has been awarded and entered into, the consideration of exclusion grounds and debarment is, as Chris has said, it's part of the selection stage and applies through the procurement probably up until contract award. So I'd have thought that you continue, but it would be subject to the terms of that contract. So subject to whatever the ground is that gives rise to the exclusion, debarment, whatever it is. There may be a clause which say triggers early termination or provides for some basis of modification. So that's what you'd look for. It wouldn't be, I don't think there's an automatic sort of, well, if you're excluded, you just terminate the contract straight away and suddenly have to go through a new procurement process for a replacement supplier. But so I think provided you've awarded the contract, entered into the contract, and then after that, they become an excluded supplier or they're on the debarment list, whatever the case may be, you'd have to look at the terms of the contract as to whether the grounds mean that you then need to consider early termination or whether you're able to continue. Would be my view.
Yeah, absolutely agreed. Conscious, Stephen, I was going to say conscious we were at time, but we're more than happy to pick up on questions either just now or afterwards.
I was just going to say, I can see there's just one more question come in. I think we can probably answer this quite quickly. So
should the exclusion grounds extend to subsidiary companies?
So yes, I think it is within the group company, so it's connected persons, associated suppliers. It can even be subcontractors as well. So certainly it would include subsidiary companies, and suppliers should be doing a full review to make sure whether, to check whether any of their, it's quite a big exercise because it also relates to some individuals as well, are subject to exclusion grounds.
That's great. Well, thank you. I'm sure everyone will join me in thanking Chris and Helen for their presentation, and thank you for everyone attending.
Yes, and thank you, and apologies for the technical issues.
Sorry about that.
Thank you very much. Thanks, Stephen.
I'll stop the recording now. Thank you very much.
Thank you. Cheerio.
Thanks.